Good afternoon, everyone. Thank you for joining us today for our OG Energy Education Series, AI's Impact on Legal Ethics. My name is Andrew Good. I'm a partner with Oliva Gibbs in our Columbus, Ohio office.
My name is Molly Pela, and I'm a partner here in the Houston office at Oliva Gibbs. I have been licensed to practice law for 20 years this year, and I've been doing litigation most of all that time. I've tried cases all over the state of Texas and various issues that have developed throughout that course. There have been numerous advances in technology in the legal field, and of course right now the hot topic is artificial intelligence and AI. The ethical implications of using AI, we want to review some hypotheticals, provide some key takeaways, and then try to give you the most up-to-date information, which is really difficult because there are articles that are literally published every day about new issues that come up. This week alone, there have been 3 or 4 articles about attorney disciplinary actions. Texas has a task force that's trying to address these issues. The Fifth Circuit is also looking at changes that they may need to make. And so this is a very fluid topic right now, with new things coming at us all the time. So with that, let's just jump in here to what we got going on. All right, what is AI? Here is the textbook definition of AI. It's an engineered machine system, typically software executing on 1 or more computer processors for processing and analyzing data, generating outputs in a manner that seeks to emulate human intelligence. Awesome. At this point, you have to have been living under a rock not to know what AI is or how it's used. Every week, again, there are new articles that are being produced about issues and implications of AI, particularly in the legal field, but it's not new. You guys are already using AI and you may not be knowing it. Most commonly, legal research. We had to learn how to do /S and /P when we first learned Westlaw and LexisNexis, and now it's more a Google search that's just like, I need a case that discusses express negligence and a master service agreement, and I hit enter and it pops up. So there are ways that that's already happening. E-discovery, a lot of the platforms that various vendors are running utilize AI. It's a way to categorize documents that the attorney is actually telling the computer how to categorize documents, what constitutes emails that are significant, key phrases, key terms that you're looking at. And so that's already being used. Litigation analytics and trying to figure out what what the outcome of a particular scenario is going to be. Contract management, due diligence, all of these areas are using artificial intelligence to make things easier, make life a little bit easier, hopefully capture or cast a wider net to get all of the information that you need and make sure that you're thinking through all of the various issues that come up in these different areas. Here are some specific examples of AI platforms. Generative AI, those are the ones that you're hearing about most, right? GPT, Bard, those types. But there are some that are specific for the legal industry, and those are also listed. Again, Lexis AI has got one, Spellbook, CoCounsel, you can read the list. As a quick disclaimer, we are not sponsored by any of these platforms. We're not promoting them, nor are we intending to disparage them in any way, shape, or form. We provided them as examples of things that you may be hearing about, and any reference to any of the specific platforms is consistent with the facts of cases or as they are reported. So again, we're not taking a stance or promoting anything one way or the other. Now that I have fulfilled my legal obligations of disclaimers, I always like a good pros and cons list. And here's one about related to artificial intelligence. Look, the pros, it's very simple. It's faster, it's a leaner practice. You can provide more services to more people quicker, potentially cheaper, and you can use it to generate arguments and vet other ideas on your particular theory of case. It allows an opportunity for you to consider all angles before you go argue a motion or present your case to a jury or talk to your client about realistic expectations. It's a powerful tool. And the thing is it's a tool. It's not supposed to replace your thinking, your abilities as an attorney to provide critical thinking in the process of representing your clients. What are some cons? There's some really noted racial or gender biases, like particularly if you're using it to vet applicants. There are issues that arise with that. And so if you're doing that, I would caution you to be very careful. Again, people are using it as a replacement rather than a tool to assist. We'll talk about it a little bit more, but people are blindly just accepting the output that these are providing without checking anything, without verifying anything, without reading it to make sure that it's consistent with their arguments and various things. And in doing so, they are wholly failing to comply with their ethical obligations that every state requires of their lawyers and that the federal government or the federal practice does as well. So why is this relevant? Well, again, as I talked about, jurisdictions are looking at how to address these issues, and legislation is being enacted, and there are local rules that are popping up. Additionally, it's widely adopted. Folks are using it. It is here to stay. It presents some challenges and some ethical considerations that we'll talk about, but there's significant advancements that are coming with it as well, and that are offering some really great opportunities, but the risks need to be acknowledged and considered, which is what we're here today. So with that, I'm going to flip it to Andrew. And Andrew, can you walk us through some of the ethical rules implicated by the use of AI?
Sure can. So for purposes of today's presentation, we're going to focus on the ABA model rules. We'll touch on a few state-specific relative to where Molly and I practice, but there are several ethical duties that apply to the use and non-use of AI by lawyers. We're going to focus on really 5 topics or areas. Competence, which is model rule 1.1, communication, which is rule 1.4, confidentiality, which is 1.6, Candor, which is rule 3.3, and supervision, which has 2 rules, 5.1 and 5.3. Let's start with competence under ABA rule 1.1. Specifically, the rule states that a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And if you're looking in that rule under comment 8, which is a 2012 comment, it further states and elaborates on it, says a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. Based upon the current environment and where we're going into the future, the legal industry stands to be revolutionized by AI, which is due to the large amounts of information and data gathered, the need for lightning fast research to advise on strategies and defenses, and ultimately the expected ability for lawyers to consume and secure more relevant knowledge. Lawyers need to stay up to date on the evolution and use of AI moving forward. They need to have a basic understanding of the associated risks and benefits, including how it works, what it can be used for, and how it produces results.
So Texas, although not specifically adopted the ABA rule because it uses different words, the intent and everything behind it is exactly the same. The slide here has what the Texas requirement is relative to competence, and it defines it as the possession or ability to timely acquire legal knowledge, skill, and training reasonably necessary for the representation of your client. So you can't do it if you don't know how to do it. That's what Texas requires relative to competence. Andrew, what about Ohio?
Ohio basically mirrors the ABA rule. So, making sure that you have proactive learning and knowledge of AI and adhering to that is key. And so I would recommend everybody else, as we touch on a few more slides that address Texas and Ohio, go look at your ethical rules for your state, see if it mirrors the ABA, or if there's changes, and be knowledgeable of that moving forward. So next, we're going to talk about the duty to communicate, which is ABA Rule 1.4. This rule governs a lawyer's duty to communicate with clients. So it requires a lawyer to reasonably consult with the client about the means by which the client's objectives are to be accomplished. In other words, if you're going to be using AI in your representation or in furtherance of accomplishing or trying to accomplish the goals on behalf of your client, you need to be able to consult and communicate with your client about those. Continuing with that, right, we've modeled this as if you are using or if you're not using. Right, so a lawyer's duty of communication under Rule 1.4 includes discussing with his or her client the decision to use AI in providing legal services. And through this, you should obtain approval from the client before using AI, and the consent must be informed. I recommend, if it's going to be informed, making sure it's in writing. The discussion should include the risks and limitations of the AI tool that you intend to use. If you're not going to be using AI, there are some circumstances when you're making the decision not to use it that you also still need to communicate that to your client if the AI or the tool would be beneficial to the client. And so a failure to use AI could implicate another ABA rule, which is 1.5, which analyzes and requires a lawyer's fees to be reasonable. If using AI in your representation of your client or your guidance would provide for more efficient services, meaning less on the bill, you'd want to be able to have that conversation and say why you're not using it so your client can be informed of the same.
Texas, here we go. You've got a responsibility to inform your client about the status of the matter and explain to them so that they can make informed decisions about their representation. This includes AI and whether or not you as the lawyer are going to use it.
Ohio's ethical rules mirror the ABA, so as you can see, it's the same language used for 1.4 under Ohio, so it lines up with what I just explained in terms of your duty to communicate. So now we're going to switch over to confidentiality of information under Rule 1.6. So specifically under 1.6C, it states a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of the client. Now again, if you go into the comments of this rule, comment 4 states, Paragraph A prohibits a lawyer from revealing information relating to the representation of a client. This prohibition also applies to disclosures by a lawyer that do not themselves reveal protected information, but could reasonably lead to the discovery of such information by a third party. Now, third party is going to be the two key words that I will be focusing on as this evolves with AI as to whether or not it could be considered a third person or who has access to the information.
So Texas largely adopts that ABA, changes a little bit of the word. The lawyer shall not reveal confidential information related to their client that's reasonably discoverable. Touching on Andrew's point, whether or not AI constitutes a third party and whether or not it's reasonably discoverable, all issues that are going to have to be vetted and addressed. Andrew, what about Ohio?
Ohio mirrors the ABA rule. The use of AI tools may require client confidences to be shared with third-party vendors. In other words, you're entering information into the AI to get responses or output, and there are questions and steps that lawyers need to take to ensure that the client's information is appropriately safeguarded to prevent breaking privilege or an unauthorized disclosure. So what are some of the issues and concerns with this? One would be divulging confidential information to feed the algorithm that AI is based upon. Once that information is out there, you have to have an understanding of how it's being used beyond you. So once it's inputted into the AI, how is it being used? How is it being stored? So example would be someone types into the matrix or the algorithm, my client X has a policy that is Z, or my client has 3 prior accidents similar to this, or divulging proprietary information, right? The foundation of the trade secret is this. It could be in a contract, it could be in a document that it's being summarized. There are a lot of things and a lot of issues that we just don't know yet, but being aware and asking the right questions if you're using this technology and these tools will help safeguard you and safeguard the client. So next up, we have candor to the tribunal under ABA Model Rule 3.3. Specifically, 3.3a states a lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by a lawyer. Comment 8, the prohibition against offering false evidence only applies if the lawyer knows that the evidence is false. Now, if any of you have been following AI and specifically some of the incidences or problems that have popped up with use by lawyers, you'll know where we're going with this, so stay tuned for some slides ahead.
The lawyer shall not knowingly make a false statement of material fact or law to the tribunal. And if you've offered that material, then the lawyer shall make a good faith effort to persuade the client to authorize the lawyer to correct or withdraw that false evidence. Again, it doesn't do anybody any good to be lying to courts for lawyers, clients, anybody.
Ohio simply mirrors the ABA rule. Next up is our last rule that we're covering. It's the duty to supervise under ABA rules 5.1 and 5.3. Without reading both of them, under these rules, lawyers have ethical obligations to supervise lawyers and non-lawyers who are assisting them in the provision of legal services to ensure that the conduct complies with the rules of professional conduct. So non-lawyers could arguably include AI, especially as it becomes more and more used and more powerful. And I just read an article, I believe it was yesterday, what they were predicting AI to be in 10 years is now at 2 years. In 6 months from now, that could be 1 year. So it's going to be a very, very intellectual tool, and it's going to produce results similar to what both lawyers and non-lawyers are going to do. So while there's no court cases or anything else to specifically determine whether or not AI could be considered it, I would argue that it's going to come about. Continuing with that, lawyers need to be cognizant that they are or may be obligated to supervise the work of the AI utilized in providing their legal services, understanding the technology well enough to ensure compliance with ethical rules, and confirming that the work product produced by AI is accurate, complete, and does not create a risk of disclosing confidential information.
Here are the Texas and Ohio rules broken out. It's again largely the same. The intent from the ABA model has been adopted by Texas. That not only do you have an obligation to supervise, potentially the AI, but if you're a firm within a firm, you have an obligation to monitor and supervise those lawyers that are using it, and law clerks and support staff that you may have that are using these things to make sure that the accuracy of the information.
Right. Now, in Ohio, which again mirrors it, but to kind of go through this, 5.1 says a lawyer shall be responsible for another lawyer's violation of the rules of professional conduct if either of the following, right? That lawyer orders or with knowledge of the conduct ratifies the conduct involved. If you are managing associate and you're aware that that associate is using ChatGPT and you don't say anything, you let it go, or you are comfortable with that lawyer doing it, and there's a violation of one of these rules that we're talking about or others as they evolve, you could be held responsible for that lawyer's violation. Or if you're a partner or you have comparable managerial authority and you know that the conduct could be avoided and mitigated but fail to take remedial measures. So if you know that they're doing this and you know that the conduct could be avoided by you saying, hey, don't use this anymore, or going to your IT and making sure that access to these types of tools is blocked until you have vetted it, you can also be held responsible. And then 5.3, it's similar. It's lawyers similarly responsible and has the same ethical obligation over non-lawyer assistants. AI could be, and I would assume moving forward, will be considered an assistant to the lawyer using it.
Let's run through some hypotheticals here that are not so hypothetical, but let's pretend that they are. So our first hypothetical we've got It's a personal injury case. Gentleman is flying from Guatemala to the United States, and he was hit in the knee with the drink cart. We've all been there. But he files suit. Defendant in this case challenged the statute of limitations and filed a motion to dismiss. Plaintiff's counsel, for their part, received several extensions to file a response, but ultimately, when they did file his response, cited 7 cases that didn't exist, complements of ChatGPT. Defendant gets the motion, challenges the cases, says these cases don't exist, they're unsupported, brings it to the court's attention. Court then has a show cause hearing, at which point counsel then acknowledges he used ChatGPT, these cases in fact don't exist, and that he doesn't check the outcome of what ChatGPT put out. So at the show cause hearing, all right, what do we think is the outcome of what happened? Were there sanctions, disciplinary proceedings, criminal charges, or disbarment? One of these is the right answer. All right, anybody got a guess? We're narrowing it down. Sanctions. That's right. Ultimately, he acknowledged the mistake and took responsibility, but was sanctioned. This wasn't a slap on the wrist. The attorney was sanctioned. All right. Hypothetical case number 2. Similar to the last hypothetical, but in addition to citing non-existent cases, the attorney cited cases that actually existed, but attached the wrong holding to the case. So the case was in text, but it didn't stand for what the attorney proffered to the court that it did. What's the outcome here? The firm takes responsibility and acknowledges its falsities. I will give you the same options: disciplinary proceeding, criminal charges, disbarment, sanctions. Guesses? The firm took responsibility, acknowledged its faux pas, and ultimately was sanctioned, but didn't face stiffer penalties because of it. All right. Hypothetical number 3, the old doubling down. Attorney drafts a motion with false cases, false citations, much as we've seen in the other one. But here, prior to the hearing, the attorney becomes aware of the falsities, doesn't tell the court about it, doesn't withdraw the motion. My favorite part about this is that when he's confronted with it, blames the law clerk. Awesome. What a great, great dude. All right. So now we've got the attorney becoming aware of the situation and not fixing it in front of the court. Same options here. What do we got? What do we think, kids? Disciplinary proceedings. This guy his license was suspended for a year and a day. 90 days to be served, and the remainder to be stayed upon the successful completion of probation. This was becoming aware of the situation and not doing anything to correct it. The biggest issue, it looks like, between this one and the prior ones was not accepting responsibility and not falling on the sword in front of the court and saying, this is what I did and I made a mistake. The last one, man, that attorney just tried to burn it all down, I guess. These are actual cases that have been reported. So the first case about the guy flying from Guatemala is the Mata versus Avianca Inc. It involved a New York attorney that had been licensed for over 30 years that used ChatGPT. And in the hearing, he noted and said, I couldn't fathom that ChatGPT would produce fictitious cases. And that probably is a lack of awareness of the technology and of what's happening, in addition to not checking it. Email me, I'll send it to you. This is an example of repeatedly what not to do every step of the way. So fine, they use the AI, they blindly accept the output. You've got attorneys blindly signing pleadings for other attorneys due to licensure issues. If one attorney is not licensed in the jurisdiction, so they're signing it under the other guy's name. He's just blankly signing off on anything. He's not checking all of this, which included the affidavit that one of them signed at the show cause hearing. It's the old adage of when you're in a hole, stop digging. And God bless the fact that they only got sanctions, I think was kind, if I can be honest. But Like, you already know the results, but read it and maybe teach it as an example of what not to do every step of the way, I think. The second case is a California eviction matter. This one had fake cases, and it had cases that were misconstruing the holdings of those cases. In fact, it had nothing to do with eviction law at all, the cases that this lawyer cited. In it, the judge stated that this was an entire body of law that was completely fabricated. And again, provides a cautionary tale about blindly accepting what these AI tools can generate. And then my favorite, the old blame the law clerk case. That's the People versus Crabill. It's out of Colorado. It's not a, I'm sorry, judge, I didn't know. As Andrew went through, and as we went through, this violates multiple of your ethical obligations as a lawyer, and they can have very, very serious consequences to your legal career, to your licensure, for your firm, if you're a supervising attorney, for your supervising attorney. And so it just needs to be very, very careful. These cases are becoming more frequent. This Colorado case was November of 2023, which is not that long ago. So Andrew, I'm gonna pull you back in here. What are some of the key takeaway from these cases relative to the ethical rules?
As Molly mentioned at the beginning, AI has the potential to be extraordinary for the legal industry. Lawyers will be able to quickly develop logical decision-making AI systems that will provide immediate, efficient, and streamlined legal analysis of issues and questions, analyze and summarize massive amounts of data and information. It will provide incredible client service capabilities, and it has the potential really to level the playing field across not only clients, but across lawyers. It'll be able to level the playing field maybe from the small solo practitioner to the large law firms because of the capabilities that it will be able to handle in the assistance. But AI is still relatively a new technology, and only a few people truly understand how it works or how it could potentially malfunction. So without understanding it, and it's challenging to ascertain what ethical hazards AI can create for the legal industry and for attorneys themselves moving forward. The key takeaways we've come up with, especially for this first one under Rule 1.1 for competence, is know the benefits and the risks associated with AI and the relevant technology you're using. Verify both the existence of the cases and the content of the cases cited in AI-generated product. There's negative implications of using AI as a replacement rather than a tool. Use it to do things that can help you actually perform your job, but don't let it replace your job. So key takeaways relating to Rule 1.4, which again is communication. Right? You need to understand whether the use of AI will benefit the client or not, meaning not only in your strategy and your representation, but also remember on the billing side of things. So that can be implicated under Rule 1.5. Discuss the use and or non-use of AI with your clients. Explain to them all the risks, the benefits, allow them to make a decision, and you must obtain informed consent from the client before using. Now, how you do that is up to you, but it must be informed consent. Can't stress that enough. Key takeaways relating to Rule 1.6 concerning confidentiality. Whatever third-party AI provider you're using, discuss their safeguards in place, their cybersecurity, their confidentiality safeguards. Ask about the type of information that is going to be provided, how it's provided, how it's stored, what security measures are in place with regard to the storage and use of that information by that third party. Make sure that the data and information that is not being inputted in there for your use is being sold to other third parties, much like we can see nowadays. Who is going to have access to that information? Who is going to be able to read, review, and discern those types of things? Do not use it unless you're confident that the client's confidential information will be secure. All of these issues and safeguards are put into some sort of contract that you're entering into this provider with, so that if somebody screws up, hopefully you're safeguarded against it, which would obviously hopefully safeguard your client. So key takeaways relating to Candor under Rule 1.3. In using AI, right, you want to make sure you're complying with the ABA panel rules and your states. You want to make sure that there's transparency and accountability, and there's the importance of timely acknowledgement of mistakes. Like Molly was explaining through the hypotheticals and then the real world examples, if you screw up, own up to your mistake to the court, right? You may get sanctioned, you may not. It's better to do that than to argue and continue to move forward and deny it, because obviously that leads to further problems and further issues for you when you could have just fallen on the sword, so to say. So that's why cover up is worse than a crime, right? Covering up the falsity and blaming another is far worse than owning up to your own mistakes. Some key takeaways relating to rules 5.1 and 5.3 regarding supervision. Supervise the work of the AI, supervise the work of the associate or non-attorney or attorney. If they're using AI in a fashion, ask those individuals if they are using them, right? They may be using them for their everyday daily tasks or generating letters or things like that. They may not think has or contains confidential information, but make sure you ask and make sure you convey to them the importance of understanding this, and that if they are going to use any of these things, they'll let you know or indicate that it's a policy that they don't use it unless there's complete compliance. And you need to make sure that you understand the technology well enough to ensure compliance with the ethical duties, also with the duties owed to your clients, right? That's the next step, is you have ethical duties to your clients, so they mirror one another for a lot of the parts, but make sure you're complying with them and you understand them in totality. So if we were to look and flip this, right, what about AI with using discovery and document retention? So some tips based upon what we've kind of talked about here today. Review and apply your document retention rules for AI models, right? Make sure that's being implemented. Appreciate the data and the guardrails for accepted AI models, right? Understand those, ask the questions, get the information, get it in writing, and be able to protect yourself and protect the data that's going in. Document and log all decisions in use on AI, right? So if you're using it, right, you should be documenting that, whether it's through your billing procedures or policies, but otherwise you need to keep a log so that when stuff hits the fan, you have a log, it's documented, it shows who did what, where they got it from, what platform, and how it was generated, so that you can protect yourself and you have the receipts to hopefully further support you. And preserve all AI accounts. So make sure your personal versus work accounts are separate, because it's a data consuming machine that is consistently developing and enhancing itself. So if you're mixing one, the questions you may be asking or the things you may be using for a personal basis may conflict in some instances with what you're doing on the work side. Also, I would say don't use your personal one if you're going to be working on work information. Try to keep it separate, and hopefully you have secure logins.
All right, guys, we're kind of coming to the end here, but again, in case the horse is not dead, we want to kick it a couple more times. But some final thoughts here. Again, communication is the key with your clients about whether you're going to use it, whether you're not going to use it. In Texas, flip to the back of the bar journal and see why lawyers are sanctioned or disciplinary actions are fine. And it's communication is the biggest one. Maybe it's status of the case mostly, but it very well we could start seeing these things about bad motions that are filed because you relied on AI, and your client finds out and their case is lost, and now you're facing disciplinary procedures for this. Second one, check the output and make sure that it holds what you're saying that it holds, that case is in support of whatever argument that you're making. Understand what your obligations are under the ethical rules, and appreciate the risks and the benefits associated with the use of AI in legal work. It's not going anywhere. It's here to stay. So how can it work for you and not against you? But to do that, there's some education that you need to undertake and comply with your ethical obligations about it. And don't compromise any of this stuff as you're going through it. If it's not working, abandon it. Call your client and say, look, I know you wanted me to do this. It's not working. The information it's providing is incorrect. I'm going to go old school and pencil and paper and type this out. And that's what I need to do as your lawyer to give your case the best shot. And then there are some tasks that can easily be handled by AI. If it's a routine letter or a routine email or anything, that's something that you can put through AI, maybe get some templates and some different things, and don't have to reinvent the wheel. There's a line, and it's not a bright line, and it's probably a fairly fine line. Common sense will take you very far. But again, if you're checking the output, if you're reviewing all of the things, if you're using your human critical thinking skills to what the information is being provided, I think that you can identify it and know it with the backdrop and support of the ethical rules and obligations that are required by your jurisdiction.
Yeah, and Molly, following up on one of that, the one thing I would say is, with this technology being advanced, right, we still don't know the true capability. One of the big red flags and alarms that pops up in my mind is it's going to miss something. It's going to miss something so critical that either you or your client is going to be blindsided. Okay, so that's not good for everybody, because what we don't know is if it's digesting this information, and it could be thousands and thousands and thousands of pages or millions of pages of documents or information. We need to figure out, and what everybody needs to be cognizant of, is how is it going to figure out what information is relevant, what information is key. That is going to be, in my opinion, a long process and procedure to set up those AI matrix algorithms to determine that. And so at this point, right, you, the person that would be doing the work, are the only ones that really know what's truly, truly important for your strategy, right? There may be things that you're thinking of that may be setting it up down the line. So while this is a tool, again, it's not going to be replacing you, right? And that explanation needs to be there. So if it's we need to go through the documents one time over and pull out all of the information that we believe is highly relevant, then have the AI be able to digest and summarize that. That's a different thing. But much like Molly said, know where to draw the line in the sand to where, it's kind of like the hairs are starting to grow on the back of your neck. If something can go wrong, right? What could go wrong here? What could it miss? And those types of questions, I think, if you keep in the back of your mind when you're using it moving forward, will help guide you in the right direction.
Agreed. Another note here is to check your local rules. A couple of jurisdictions are requiring some additional certifications and acknowledgement of the use of AI. Here's one from the Northern District of Texas. This other one is the Federal District Court in Hawaii. That is requiring an additional certification about the use of AI. The federal courts are considering whether any of this is necessary, because the rules as already written is when you sign something as an attorney, you're pledging that it is true and correct. And these requirements actually are a little bit too expansive. And so it begs the question, well, I used Westlaw to do research, and is it too narrow or too broad and everything? Ultimately, the goal is the same. The courts are trying to prevent false information being presented to the court as true, and disingenuous arguments being made, because as we all know, it can lead to bad law and some other consequences. So check your local rules. I don't know how long it will become an issue, but as the technology changes, the Texas article that I read was discussing, there's a task force in Texas that's addressing these issues currently. And the article related it to earlier when we started saving everything to the cloud, and whether or not that could be secure, and whether or not what implications that had of saving confidential documents and client information to the cloud. And you seem to have gotten through that okay. So I'm confident we will get through these issues with AI and come to general use of it and general understanding moving forward that will be acceptable to all. But we're just in the making of the sausage of it right now. Ultimately, we'll get to the other side, but as it's getting worked out, there are just some things to be aware of and some issues that need to be addressed and need to be thought about. And to Andrew's point of just considered fully uh, as you're utilizing this technology and as it gets better and better, hopefully moving forward.
Molly, I would add one thing on that. So in addition to checking your local rules, ask your employer. One thing I would say, I mean, especially in Ohio, so Ohio state government employees are now required to adhere to a policy regarding the use of AI, and that's for all employees within the state government. And so I would imagine if state governments are starting to do that, that will trickle down to local and others. And then court systems could start looking at that. And much like the task force, when one state does it, it usually is like a wildfire and goes to all the other states. So being proactive on this and asking the right questions and making sure you stay up to date on that in terms of policies is only going to help you further.
Excellent point, Andrew. Excellent point. And your law firm, even as an associate, your law firm may have enacted similar policies that says we're not using it. It's in our engagement letter, and we're not using it, and we don't want you to use it. And then for firm owners and partners and managers, having those discussions with your partners and figuring out how are y'all going to make it work, and are y'all going to develop a policy, and then communicate that policy to everybody. So there's just a lot of conversations that need to be had about this and what's the best way to move forward with this technology out there that, again, is not going anywhere. Andrew, we've got some time for some questions and answers. Are there anything else you want to add?
No, but I do see that we have some questions here. So the first one is, how do we best stay up to date on advancements in AI technology and their potential impact in the legal industry? So for one thing, Google, Bing, any of these things, I mean, if you just do AI recent events, AI ethical standards, things will pop up. Go to the news section, go to Reuters, use Lexis or Westlaw, whatever search engine you're doing. Another good avenue maybe to look at is your bar associations if you're looking at those. I know in Ohio, they had produced a pretty good article detailing, the kind of pitfalls and uses and where they're going. The other thing maybe is, if you are a member of the bar association, most of them have lobbyist attorneys that kind of stay up to date in the changing of the legislation and laws. You can pose that question to them, say, hey, what's going on and where are we going with this? They were going to have the more insider information that you may want. But staying up to date and how it's impacting the legal industry is simply just a few clicks away. It's sad you're using technology to learn more about technology, but that's where we're at, and that's the way you're going to stay up to date on it. And ask your colleagues and your friends and people in the industry, what they're doing, what they've heard as well. Molly, we got another question. Is there a way to assess the quality and reliability of generative AI tools for lawyers?
Read it. I mean, look, talk to your friends, work with your colleagues and say, hey, look, I'm interested in this. What have you found that works? What have you found that doesn't work? And then, start simple. Start with a letter that you might write, or a letter brief, as opposed to, a response to a summary judgment that's huge. Engage it for yourself. It's going to take a bit of work on the front end to see if the information you're being provided. At this point, I'm hesitant to say, look, if you've done it a couple of times, then it's probably good. it scares me. I'll tell you, I mean, I'm a little bit old school in this, and this AI stuff, it's a little tricky and it's a little scary. I will probably be belts and suspenders for a while until there's just more information that these are providing reliable results. That's the decision I'm going to make for myself in my practice. I encourage you to do the same, particularly as I read uh, lawyers getting sanctioned and different things. And I'm not a 30-year lawyer that's blindly going to accept it like some other folks, but that's it. It's just reading it, and until the kinks get ironed out, I think that's really the only way that you can ensure that what you're putting out with your name on it is good.
Okay, got another question, Molly. Are there any notable success stories or case studies where AI has significantly benefited clients or individuals? I can answer that partially, and then Molly can go. Through my conversations, through going to some trade association events, these types of presentations, similar to what we're doing, happen all the time, and there are a lot of conversations and dialogue. I am aware of certain companies that are using AI internally, meaning they've had something built specifically to their needs. It's not shared with the outside world. It's more of an engine that is able to absorb tons of information and summarize it and produce reports and certain things. And then it also is helping them produce future planning. But the data points that some of our clients look at and have in terms of documents and information that they need is so vast that the time commitment to really be able to absorb all the information, understand it, is very, very large. And so they're building it. I know personally a few friends of mine that are attorneys that use some of the AI technology that Molly specifically highlighted at the beginning within their practice. They use it more as a tool, but they use it in contract review. And a lot of those will help summarize or highlight key terms or certain provisions in terms that may not be beneficial or will be counterintuitive to certain laws within their state, and it's becoming more and more advanced, meaning that instead of having the catch-all provision that the severability is saying if any one provision in this contract is found to be void, invalid, illegal, etc., the rest of the contract would be there. Well, essentially what it's saying is it's finding those provisions to say, hey, here's a case that we understand conflicts with this terminology that would void it. So it's helping streamline these and making them write better and picking up on issue spotting sooner rather than later. So it's precaution on the upfront versus on the back end where Molly and I would come in as litigators to try to save the day. But what do you think, Molly? Do you have any notable success stories or case studies where it's significantly benefited clients or colleagues?
Similar to yours, it's been word of mouth and discussions I've had with colleagues and cohorts and peers at various different things. I think that from a news perspective, look, the ways it goes wrong is infinitely more attractive and clickbait material as opposed to the way that it goes right. But everybody that I've talked to and the success stories that I've heard, much like what you're saying, Andrew, is we kind of start there. Sometimes it's easier to start something when you've got something to work with as opposed to staring at a blank page and starting from scratch. So they're doing it the right way, or what I consider to be the right way of using it as a tool, taking it step by step, maybe setting up templates for emails or different things about how they're going to handle it, engagement letters, those types of things. And then reviewing it and making sure that it says what it needs to say and fits for their particular practice. So hopefully we'll start seeing more articles about how it can more be integrated and be used. But unfortunately right now, the information that pops up that we're inundated with is how it all goes wrong. So.
Well, I think we have time for one more question. I think this is a good one. how would you verify AI answers to ensure their accuracy as opposed to it misleading you or lying to you in a convincingly manner? For me, it's, those the crutch information, right? So if you're using it for research, right, and it's producing results and case citations and different things, it's simply going to those cases through your Lexis, Westlaw, or whatever type of technology you use to verify those. Make sure that what it's citing to and the ruling or note within the same is there. It's not just made up. And to be honest, that can simply be, the first step would be you can Google any case that is cited and it should populate in Google to tell you if it's real. And then you can find it that. Or it may be, as this moves forward, using different AI tools that are producing consistent results. One would be, case sites, which, Lexis AI and certain other ones are working on. But most of the AI, if you're using ChatGPT or Copilot through Bing or something like that, they actually give you and they link you to the citations of where they're getting this information from a lot of the times. And I know I was reading that there is a way through certain technology platforms to ask them to produce the citations from where the AI is getting the information or summarizing the information. So there's a lot of ways to do it. It just takes a little bit of digging, but it's remember, don't just agree with it flat out. It's checks and balances across the board.
I agree with Andrew. Just check it. All right, guys, here's what you've been waiting for. The credit information. These are the AAPL codes, the Texas CLE approved credit code, and in Ohio. We are pending Oklahoma and Pennsylvania, and hopefully we'll have those. We ask that you please complete a post-event survey. Let us know how we did, whether or not this was helpful or other topics that you'd like to have. And we'll shoot out a follow-up email next week with further information for those of you in Oklahoma and Pennsylvania that need it. Here's our contact information. Andrew's in Columbus, Ohio office. I'm here in Houston. And happy to answer any further questions as best we can. It's a dynamic topic that changes almost every day. So let us know if you have any more questions, and we're happy to help. Andrew, anything else?
Yeah, I was going to say, if anybody is going to be at the NAPE Summit next week in Houston, Texas, we will have a booth. I'm sure there's lots of events, but feel free to reach out to Molly and I. We would love to meet you in person. It's always nice to shake somebody's hand, get to know them, and hopefully I'll see you there.
Awesome. Thank you, guys.